Welcome back. My name is Patrick Noland. This is Pat Talks Law. You know, I had started doing an in-depth review of Judge Joyce's opinion on the Sarcoxie case. I've probably shot about 20 minutes worth of video on that. And it's sitting on my computer in my office, and I stopped because I realized that most people don't care. The intricacies of the law and the way Judge Joyce used her language. The fact of the matter is that her opinion is, in my opinion, correct in some areas and flawed in some areas. The main issue that I see is that in the Sarcoxie case, they focused on the number of licenses and the caps on license. They also focused on the right to farm amendment. Now, hindsight, which every lawyer can do, and any of us can do, is pretty clear. You can look at it and say, well, that didn't work. It must have been a dumb argument. It's not a dumb argument. It was actually a good choice. However, I think somebody didn't look at the history. Judge Joyce previously ruled on marijuana and right to farm years ago, after the right to farm amendment had passed. It was in a motion to dismiss brought forward by district defender Justin Carver, and she ruled against that person who was growing marijuana in their basement. I don't remember the details of that case. I used to have a copy of Carver's motion, and damned if I know where I put it. So, with Judge Joyce's history and previous opinions on this subject, you had to wonder how they were going to distinguish the medical marijuana claim from a generic right to farm issue. And oh shit, traffic is stopped. Ooh. Okay. Hope it wasn't an accident. Oh, I think you're getting ready to do a convoy with the wind tower stuff. It'd be nice if any of these people wearing the vests are supposed to be doing road control and traffic safety were actually doing it. That'd probably be too much to fucking ask, right? So, anyway. So given Judge Joyce's history, you would think that the attorneys involved would have given some record, some acknowledgement of her previous ruling and shown why this is distinguished from her previous decision on the subject. They really didn't. They argued the caps. They argued that the state was improperly evaluating it, and Judge Joyce ruled that they held public comments, the regulations were in place, and that the state did not act in an inappropriate manner. Now, under administrative law, did they act right? So they reviewed it, but the essence of it is they followed the rules, they followed the regulations, comments were posted, they held public hearings, they listened, they made some adjustments to their proposed regulations based upon comments, But the state determined, the Department of Health and Senior Services determined that there was no need to increase the number of licenses from the floor. Now, they made what I think we will all agree is a bullshit economic evaluation based on flawed information, and possibly intentionally so. They issued licenses to people who are not opening stores, and they're not reissuing those licenses. For example, in Kirksville, there were 3 dispensary licenses issued, only one of whom has a physical location and has been approved to open, and they are not open. So where does that leave the consumers? Well, I'll say it's far short of the 24 per congressional district that we're supposed to have, and I think it's pretty clear that Kirksville is not an outlier. So we'll see, but there should be at least 2 more license holders opening, and there aren't. Their leases are, the properties they claim to have leased have for rent signs and are vacant. So anyway, so Judge Joyce, you knew what you were going to get. If you know you're going to lose in front of the judge because of a certain opinion, because of a certain opinion or point of view the judge has, you have to take your case from the get-go, planning the appeal. And that's where you have to go. You have to tee it up with evidence. You have to set it up so that you can make those arguments. The problem is that I don't think they did that. I don't think they approached it from the point of view that they were going to lose at this hearing. This case, the Sarcoxie case, first one that's been tried, didn't address the arbitrary and capricious manner in which the scores were tallied. It didn't address outright corruption in the scoring. It didn't address corruption within the department and the companies that receive licenses. So while this is it's an interesting case, it's not a case that's going to be dispositive. This is not going to be, the Sarcoxie case doesn't mean everybody appealing is going to lose. What the Sarcoxie case shows is right to farm is not going to be your successful avenue. And arguing the number of licenses is not going to be a successful attack. Amendment 2 set a floor on the number of licenses. People keep referring to this as a cap, and it truly isn't. There is no cap on the number of licenses. There's a floor. And those are 2 very different things. The state has to issue 24 licenses per congressional district for dispensaries. Okay? That's the minimum number. The state may issue, based upon need and criteria, as many additional licenses as are needed to serve the consumer. So, what does that mean? That means that DHSS has a responsibility to evaluate the numbers, determine whether or not they need more licenses, and if so, hold the awarding process. They base their numbers initially on the Constitution and their assessment of what they thought participation would be. Now, I think we can all agree that participation projections were way off by everyone except perhaps the users. They simply just didn't get that right. And if you read those arguments in Joyce's opinion and her findings there, she makes statements that restricting the access to or the production of medical marijuana serves the state interest by preventing diversion of legal marijuana to the illegal market. Yeah, that's not going to happen. What will happen is the price comes down. It isn't diverted to an illegal market. The price comes down. It's an artificial fixed price. What happens while the price is too high is that the illegal market provides the product. You actually have infiltration, not diversion. You have an infiltration of illegal marijuana into the legal medical marijuana market. Now, I know a lot of people who have said that they're just going to go out, they're going to buy the 1/8 at $60, keep the package, and put their black market marijuana in that package. Okay? By the way, I don't believe that to be an appropriate thing to do. I would tell you that you probably shouldn't do that. I have no idea how they would ever convict anybody of that without doing a analysis of what strand or trying to identify that particular marijuana. But I think they can check and see when that package of legal medical marijuana was sold. And if it's a year old, brother, we know you still don't have 4 ounces. I'm sorry. So you got to have some common sense. But my opinion is that as long as we have artificial limits on the number of licenses, as long as DHSS is limiting the number of licenses based upon their analysis of need and supporting the current manufacturers and producers, which is essentially MoCan, then we will have a situation where diversion is not a problem, but infiltration is. And that infiltration of illegal marijuana creates much more of a health risk to Missourians than possible diversion. If the basis is health, then the issue is not diversion, but infiltration of marijuana. So I think that entire span of argument that Judge Joyce included in her opinion is wrong. Logically, it's wrong economically, and frankly, I can't tell you whether the plaintiffs, whether Sarcoxie Nursery had promulgated the argument that I have, that infiltration is a more serious issue than diversion, and that the state is overlooking that they're creating a thriving black market as opposed to protecting the Missourians. So where does that leave us? Well, frankly, I think Sarcoxie Nursery in a little bit of a bump. They got an issue because I think the judge ruled correctly on the issues of merit in that case. The dispositive issues are that the state has the authority, DHSS has the authority to evaluate whether additional licenses are needed. Right to farm does not trump the state's regulatory interest, which we could have told you in advance anyway. So the issue there becomes one of how is the state managing its regulatory scheme? In the issuance of licenses, that's where the issues come in. That's where all of the corruption that was released in the Cannabis Consumers Report, all of the corruption's been alluded to, and self-dealing by interested members, including Missouri legislators. All of the scoring issues that have been raised, and I should say that there was one scoring issue that was raised, but frankly, I'm not sure it was raised in the best way. They argue the geographical bonus points, but only the geographical bonus points, as creating an unequal field. And I think they argued the wrong thing. They argued that wasn't constitutional, and Judge pointed out correctly that their argument was based on an area of law that only applies to the state of Missouri, not to the medical marijuana program, to the legislature, not the department. So, what does that mean? That means that while we may not like the result, by and large, Judge reached the right conclusion in denying Sarcoxie's appeal. With the caveat, of course, that I don't think Sarcoxie appealed the right issues. They might not have argued the right issues. So that's where we are. There are still hundreds more cases, and I know some of the lawyers handling them. The issues that I mentioned are going to be addressed in some of those other cases. This is not going to end anytime soon. And as we all know, that as Judge mentioned in her opinion, that the state has absolutely no problem spending every penny of the veterans' money, while blaming the appellants for that expense instead of running a fair licensing scheme. Frankly, they would have been better served on a first come, first served basis, or even a lottery system. Just have a lottery. Here you go. Number 159, that's you. Do you meet the requirements? Yes or no? No? Okay, draw a new number. That would have been a better system than what they did. But that would have taken control away from MoCan. So, anyway, please hit like, subscribe. I will be doing more. Obviously, I've got long drives in the wee hours of the morning. Thank you. Bye.